Welcome to the People's Law School. My name is John Brinkley, and I'm a member of the Alabama Association for Justice. It's my pleasure to introduce to you tonight Matt Glover. He's an attorney from Tuscaloosa, Alabama. He went to college at the University of West Virginia. Upon graduation, he came to Tuscaloosa, where he was taught by his teacher, Bobby Prince, who is now the senior partner at their firm, Prince, Glover, and Hayes. What you need to understand is that Bobby Prince has taught hundreds of students, usually about 200 students in every class in most cases. And he saw something special about this young man that you're going to hear, Matt Glover. And it's my pleasure to introduce him tonight.
Hey, thank you. Appreciate it. I get to do this every year, and really it's one of those things that I look forward to the most. So I appreciate the opportunity to be back, and I always get to speak on a different topic, which is nice. Some of the guys at the office, they have their one topic that they know a lot about and really enjoy talking about it, and usually they get to pick and they say, here's the one that's left over. And so the one that's left over tonight is product liability, which happens to be really my favorite subject. When I graduated from law school in 2002 from the University of Alabama, we had a family that moved to Tuscaloosa because we have a VA hospital there. And it was a special program that the VA hospital had which treated service people, men and women, who had traumatic brain injuries. And this particular Marine, who was just a few years younger than myself at the time, had been injured over in Japan and had a traumatic brain injury as a result of a piece of equipment that failed. And so I went over and met, of course, I'm brand new. I mean, you know, just fortunately passed the test to become a lawyer, which my dad always said, can't be that hard, all the lawyers I know. Thanks, Dad. but I passed and made it over to the VA hospital, and really that experience, you know, at least in terms of my career, really changed it. Because for the next 4 or 5 years, I worked more on that case against the manufacturer of that equipment than I worked on, and probably worked on any case even up to this point. And it's the only case that I can think of that while the case was pending, that Marine died, and because of his injuries. The case did get resolved, but I keep a picture of that Marine in my office, and every day that I'm at the office I get to see it because it reminds me of some of the good that lawyers get to do, because that case changed the way a particular product was manufactured and installed, not only at that one particular base, but across the world. And it's real easy, I think, when you drive down the road, you know, you see the advertisements for lawyers, and I won't comment on that. But it's real easy for the public to think that all that lawyers do is look for people that are hurt in a car wreck and look to hand out a check. And that does happen, but there are a lot of cases out there that have the ability to change circumstances and products, and that's what I really want to talk to tonight. Now, I come into this, and I know everyone received a copy. I gave out a handout last year, which was this. This year I said, I'm going to bring the actual book, and so it's free. I gave it to you. If you're watching this tonight, you can download it from our website, princeglover.net, or princelaw.net, I'm sorry, or you can call us, and we'll be glad to give you a copy. But it talks about a lot of the concepts that we're going to talk about tonight, and that's product liability, which means this: if someone is injured or killed as a result of using a product, it can be any kind of product, then this is the area of the law that I'll be talking about tonight, because as you probably know, the law in just about every state is different on so many different topics. If you are injured in Alabama, the law will be different than if you are injured in Tennessee or Arkansas or Georgia or Mississippi or in a foreign country. And so tonight I'll be talking about the law in Alabama, which has some similarities to laws in other places, but we do get people who watch this who don't live in the state of Alabama. And so if you hear something tonight, that may not actually be the law which happens in your state. All right, so you see the screen. You see something called a recall, right? Anybody that has owned a vehicle, or even if you haven't owned a vehicle, you've seen it on the TV, that every so often there is a product or a part of that vehicle that is recalled. And let me just tell you, if you ever get that notice in the mail, I know it's not convenient to have to go down to the service station and wait 4 hours sometimes to have what appears to you to be a very minor part on the vehicle to be replaced. But let me tell you, if something happens, they know who received the recall notices, they know who didn't show up, and if that's the particular item that fails and you didn't take the initiative to get the part fixed, you're going to have a hard time, or your family's going to have a hard time in a case like that. Well, how do we get to a recall? I mean, the company just receives notification. We've got a problem. We may have 2 million of those vehicles on the road. So let's just send out 2 million notices, get everybody in here, we'll fix the part. Does it happen that way? Well, not quite. And admittedly, I come from this from the perspective of someone who represents injured people or people who have lost a family member as a result of a product failure. But I can assure you that whether it's on my side or the other side, both sides would agree that manufacturers of vehicles, for instance, they're not that quick to issue a recall notice. Because as you know, that's a very expensive venture, which we'll talk about later. So one of the things that product liability cases lead to many times, yes, obviously resolution for a particular family, but that one case may lead to a manufacturer of a vehicle, for instance, just as one example of a product, to actually take the initiative to issue a recall notice. And if you've seen, whether it be the Toyota or the GM vehicles over the last couple years, if you've paid particular attention to those cases, it was often a recall that was delayed, and it was determined that the company actually had information for quite some time, but through product liability cases and the scrutiny that takes place in those cases, eventually the manufacturer issued a recall notice which affected other families out there. Okay, so let's talk some very basics first. As I mentioned, the law in Alabama is different than other states. Our product liability law comes from two sources. One, the legislature. If you look at what's called the Alabama Code, and there is a book, very large, several volumes, called the Alabama Code. That's the written laws in this state that the legislature passes and the governor signs. Part of our product liability law was written by the legislature. Well, as often happens, that has to be interpreted because sometimes there are certain provisions that are not clear. And so the law is developed, and eventually we have what's called case law, which is the law that has come out from the courts in our state, mostly from the Alabama Supreme Court. And the way that works, in case you don't know, you have what's called state court judges throughout our state. Each county has at least one. Some counties have multiple judges. They make additional or initial determinations as to law. Lawyers have the right to appeal a judge's decision. And that appeal eventually makes its way up to the Alabama Supreme Court in Montgomery. And when the Alabama Supreme Court makes a decision, many times they write what is called an opinion. And that opinion is referred to our case law. And that case law helps guide attorneys, guide judges, guide injured people on what the law is in the state of Alabama. And on one topic, that would be product liability. So when can someone be held responsible in a product liability case? Well, first off, the person who designs a product. If you design a product and that product fails, or that product is unsafe by design, you can be held responsible. If you manufacture a product, let's just say someone else designed it, but you manufactured it, you can be responsible for product liability. Maybe it was the design that was bad. Maybe it was the way it was manufactured. It was bad. Either case, you can be held responsible. Well, actually, if you're the person who sells the defective product, you can be responsible. So when you look at product liability law, it's not just the manufacturer, it's not just the designer, it can be the distributor, it can be the person who sells it. So this product liability law, it applies to a lot of different entities. Now let me be real quick to say this, because these are some of the most important legal concepts that I'll be talking about tonight. A person who designs or manufactures a product is not responsible just because someone gets hurt. They can design a product and that product can be used improperly. For instance, make a car. Car's not really designed to be driven 150 miles an hour while someone is over the legal limit. Okay, well, there are some cars that are manufactured to do 150. Okay, my vehicle's not. And if I drive if it can get 150 and I drive it tonight in a hurry to get back to Tuscaloosa and I hit a guardrail, that car is really not designed to be wrecked at 150 miles per hour. Okay? Likewise, even if I'm driving it at a proper speed, there may be something unique about the accident, and just because I was in an accident in the vehicle, perhaps it's questionable, maybe it could have done something different, that doesn't automatically mean that someone has a product liability case. The designer does not have to guarantee an accident-free product. Now, I know that there are some people, and especially someone who finds themselves being injured, who conclude, well, that shouldn't have happened, and maybe it shouldn't have happened, and maybe you do have a product liability case. But again, the manufacturer is not required under the law to design or manufacture a product that in all circumstances leads to an accident-free product. Okay? Now, a lot of the manufacturers would want you to believe that the way lawyers operate, that they are under the mentality that if you're injured, you got a case. I can assure you, because of some of the concepts that I'll be talking about tonight, lawyers have to be very, very careful when they analyze product liability cases. Let me just go ahead and tell you why. One, because lawyers who accept those cases, they only get paid if there's a recovery. And you're going to see tonight that these product liability cases, they are really some of the most complex and expensive cases out there. And so a law firm is fronting all of the money, many times $200,000, $250,000, $300,000, to invest in a case that if they lose, they have to absorb as a business. They don't go to the injured person or their family and say, we spent $250,000, we had a judge throw us out of court, we had a jury return a verdict for the defendant, do you mind to contribute? That doesn't happen. And so you have to be very careful in these product liability cases, because they are expensive, to make sure that if you take one and you take that risk and you bite off the costs that are associated with it, that you believe by doing so you have a chance at recovery. Which also leads to this point. while you may break your finger using a product, unfortunately, most lawyers can't accept a product liability case, and invest $250,000 if you broke a finger, because the chances of getting $250,000 is not that great. So many times when we talk about these cases, we're talking about people who are either dead through the use of a product or significantly injured. The brain injury example that I gave you earlier. Paralyzed, a quadriplegic, severe burn injuries. Those are the type of injuries that typically lead to product liability cases. The last 2 points here are very important legal concepts that we have to understand before we can really talk about a product liability case. The victim, the lawyer representing that side, must show that the product was defective. Not just that perhaps it wasn't as safe as it could have been. He or she actually has to prove that that product was defective or unreasonably dangerous. I want to cover that again. It's not enough just to show that it perhaps could have been a little safer had they designed it this way or manufactured it that way. That's not enough. Under the law in Alabama, you must show that the product was unreasonably dangerous or defective. Which means it's not enough for Matt Glover to say that, because I'm not an engineer. I've got to have the right credentialed expert to testify, which we'll talk about in just a few minutes, that the product was defective. And then the last point, not only must you show that it was defective, but you must show that there was an alternative design available at the time this particular product which was manufactured, which should have been used. All right? So as we talk about this today, we have to show, one, that it was defective, and two, not only was it defective, but there was another design which was out there available to be used in place of the design in question. All right. I could talk to you about baby cribs. I could talk to you about toasters, hot water tanks, hot tubs. You name the product. But I'm going to choose my time tonight to really speak to you about vehicles. Because chances are that is a product that we all had some connection to. All right? In vehicles, there's kind of a subset of the law when it comes to product liability, and that is called crash worthiness. Now, let me explain that just a little bit. If I have a toaster in my house, and this happened, all right? This happened back in football season. Had a couple from Huntsville who decided, they always decide in the fall that they want to visit us. And it always just happens to be on the weekend of a home game. But we're glad to have them. They came down, and on Saturday morning, one of them decided that it wasn't good enough that I had a bagel from Panera Bread. Sliced, already toasted, good cream cheese on the table. They wanted to toast it a little bit more. Let's kind of a fat bagel. And I got kind of a skinny toaster. And so unbeknownst to me, he's over cramming it down in that toaster and then comes back so we can watch game day on the TV. And the next thing you know, all of us attentive adults are watching game day, and the kids start saying, "Hey, Dad, something's smoking in the kitchen." Well, it was more than smoke. It was fire. Flames coming out of the toaster. Kitchen about got burned down. Wife tried to grab it and throw the toaster in the water, which you know that's a bad idea. Anyhow, I would have done the same thing, but I was watching game day. Toaster caught on fire. We could have said, that's a bad toaster. The toaster didn't do what it was supposed to do. Yeah, I'm sure they would have said, you're not supposed to cram a big fat bagel down in the toaster under a wooden cabinet. All right, I'm sure they would have had an argument. But that would be an example of a product that perhaps failed. We would say the toaster didn't do what it was supposed to do. With crashworthiness cases, it's a little bit different. You may have a car that doesn't do what it's supposed to do. The sudden acceleration cases. You're driving down the interstate, you're going 65 miles an hour, and all of a sudden it takes off, and it goes 90, and you can't get it to stop. That was one of the claims that we've noticed in the news. That would be a traditional product liability case. Crashworthiness is a little different. In a crashworthiness case, the victim is not saying that the product did something to cause the injury. Instead, the person is saying the vehicle just didn't protect me. Yeah, it was the guardrail or another vehicle that caused the wreck, but the vehicle as designed didn't hold up the way it should have held up in that type of collision. And as a result, the person is either severely injured or dead. There are a lot of cases out there that are based upon the subset of the law which is called crashworthiness. Okay? I mean, the manufacturers, they know when they design these cars, they're going to be in wrecks, right? If you've ever been to a car lot, and especially you take like when my wife was pregnant, you know, a lot of people can immediately determine at that point, okay, they're going to be really concerned about young children. So we're going to talk about all the safe elements of this car. Oh, this thing rolls, it can roll over 18 times, and it won't have a dent in it. Or it's past this crash test, it's past that. That's crashworthiness. You're talking about we know it's going to crash, but when it does crash, how does it hold up? And so a lot of the examples that I'm going to give tonight are based upon crashworthiness. Let me give you an example. You remember the Ford rollover cases. You may have heard those. Vehicle rolls over. The allegation was it should have held up better. The roof structure shouldn't have crushed in, because when the roof structure crushes in, most of the time that leads to the broken neck, which leads to either death or serious paralysis. So we're going to be talking about crashworthiness. Here are some of the main angles that people use in product liability when it comes to crashworthiness. I've already discussed one, and that is the roof structure. If it's in a rollover, does it hold up, or does it crush like a can so that the livable space within the compartment of the vehicle is maintained? Or you may say, you may hear this, that the seatbelt didn't work. It came undone, it came unlatched during the crash sequence, and as a result, the person was ejected from the vehicle, or the person was thrown in the vehicle and their head hit one of the structures in the vehicle. Or the airbag didn't deploy as it was supposed to, or it was a delayed ejectment of the airbag. Or this was pretty much the type of collision that you see, but the vehicle did not absorb the energy the way it was supposed to. I'll give you an example. You've seen this. You may have seen one this week. Side of the road, one car hits another from behind. The hood on the vehicle usually does this, right? You see, it's called tinting. One of the reasons it tints is to keep the hood from coming through the windshield. Another reason that vehicles crumple from front in is because with each crumple, it's real scientific, with each crumple, you're absorbing energy, and the more energy the vehicle can absorb outside of the compartment of the vehicle, the less energy there that's placed on the body within the vehicle. Energy on the body is a huge factor if you've ever watched a crash test, especially the ones that have the dummies inside. They're trying to minimize the energy in order to improve your chances of survival. One angle is the vehicle didn't absorb the energy the way it was supposed to. And finally, fires. A fire shouldn't have happened as a result of this particular type of collision. So those are your main angles, so to speak, or theories of product liability in the state of Alabama when someone looks at a crashworthiness case. All right? I'm going to speak a lot tonight about what I call heavy trucks and medium duty trucks, all right? Now, everyone remembers the Pinto, right? And of course, we all look back now and we say, that's terrible. Anybody could have seen that coming, right? You put a fuel tank there in a car. Is it really a surprise that in a traditional collision that a fire would take place? And we're going to talk a little bit more about the Pinto. But we assume that we've learned our lessons from the past, okay? That the Pinto was something that happened generations ago, decades ago, and we no longer face that type of dilemma. One of the things I hope to do tonight is to educate people here and people watching that we still have the modern day Pinto out there. And that is heavy trucks and medium duty trucks. And I promise that at the end of me talking, you will at least say, I didn't know that. And I'm surprised that the law really hasn't done more for people who operate vehicles like this. If a heavy truck, this is like an 18-wheeler, if a heavy truck ever rolls over, I don't mean a quarter turn, I mean at least on the side and then on top of the cab, you can expect this to happen. And I'll explain why that is. Now, if your car tonight gets in that same type of situation, I guarantee it's not going to crush like this heavy truck does. And I'll explain that. But I can make that promise to you. And another situation we're going to talk about tonight are the fires that occur on many of these heavy and medium duty sized trucks. This is a dump truck. All right, one of the first things that I had to learn, if I had just taken the time to listen to my dad a little bit more growing up, it probably would have saved me several years, because I know somewhere along the way he wanted me to get out of the house and go out there into the garage with him where he was working on cars and changing the oil and whatever you do in the garage. I didn't want to be out there. You know, there were too many other things that I could be doing, and I just know, looking back, if I had just taken the time to go out there, I would have learned so much that would have helped me along the way. I just thought for the longest time, and some of you will, I guarantee, be just like me. This is what is made most of the time by the manufacturer of a medium or heavy duty truck. It's a cab and a chassis, all right? I know that my dad would have told me what a cab and a chassis was, but I had to spend way too much time on my own trying to figure, this is what they make, all right? Now, you don't see a whole lot that look like that. What you see is something that looks like this, right? Or something that looks like that. I thought that was really three different vehicles. It's really the same vehicle that's manufactured the same way. It's just how it's modified and adapted after the fact. The manufacturer of the vehicle, I'll give you a couple examples. You've got GM. You've got Ford. They make a cab with a chassis. Or you can drive it. But then it goes into companies like in Alabama, we have what's called ox bodies in Fayette that will put a dump on it. So you can be a dump truck. But that's what they sell. But there's one thing, I'll go back through that. Let's see if I can do it backwards. One thing you'll notice in all of these is the placement of the fuel tank, right? Now remember, I know y'all agreed, because when I was saying, y'all would shake your head and say, yeah, on the Pinto, we put the fuel tank where we put the fuel tank, and that was a bad idea because in a collision, the fuel tank would crumple, the fire would happen, and someone would burn, all right? We wouldn't make that mistake again. Oh, you're right. We've actually, in my judgment, taken a step backwards. At least with the Pinto, the fuel tank wasn't sitting on the outside. It's just an example. This is all leading to a point that I promise I'm going to make. In all of these, we've decided that it would be a good idea to put a fuel tank, some gasoline, some diesel, not all diesel, there's some gasoline, sitting out there strapped to the side of a vehicle. And most of the time on the side of the vehicle, it's going to come into contact with vehicle coming in the opposite direction, all right? Which means you're saying, please hit my fuel tank, and I'm going to be real shocked when that fuel tank crumples, the gas comes out, and it ignites, okay? Now, surely the government and the manufacturers would not put vehicles out there with fuel tanks on the side. Now, when y'all start driving, some of you already knew that. And some of you may be saying, well, where else are you going to put it? Oh, we'll talk about it. Or, it's diesel. Diesel doesn't catch on fire like gasoline. I guarantee you, some of you had some ideas about, well, now look, I expected you to say that because of what you do, but surely our government wouldn't allow that to happen. Surely the manufacturers wouldn't. I mean, we got good engineers that work at this company. You can't tell me these people sit around saying, yeah, that's fine. We know it's dangerous. That's fine. We're going to talk about it. And the first way we're going to talk about it is the myth of the crash test. The myth of the crash test. Y'all don't have to answer this, but I want you to think through this as I say it. I thought when I got into this, the way crash tests worked, simple as this. We designed the vehicle, government, we're done. You come in and you run all your crash tests and you let us know how we did. I mean, that made sense to me because that's how homework worked with me. Teacher said, look, you got the spelling test. You get to take the test, I get to grade you, and if you don't pass, you get to sit in here instead of going out in the field. It worked that easy. If that didn't work when I got home, Dad wouldn't let me go play sports. I just thought, same thing with vehicles. I design it, hey, big bad government, you tell me if I passed. If I passed, great, I go out there and sell it. If I didn't pass, let me know what I can do different, I'll modify. It doesn't work that way. They crash test, but you don't really say, hey, here's how we did. You just sign a certification saying we passed. You don't send the certification that says, okay, we passed, and if you really want to check us, here are all our video crash tests. So you can go back and look. No, all I've got to do is say, I passed the test. Well, wouldn't that have been nice? I mean, think about all the A's I would have made, you know. Hey, teacher, I checked it. I passed. All right? Now, the government reserves the right to say, okay, if we may look, and the government sometimes does crash test vehicles for other reasons. But if you think your vehicle was crash tested by someone other than the manufacturer, you're probably assuming the wrong thing. Secondly, not all vehicles are crash tested the same way. Now, look, let's just say, last year I came up here, I drove a Ford F-150. Good vehicle. I was involved in a crash. Let me tell you, that thing held up tremendously, okay? My Ford F-150 was crash tested consistent with every standard that's out there. They're called the Federal Motor Vehicle Safety Standards, FMVSS, all right? Federal Motor Vehicle Safety Standards. Just about every test on the Ford F-150, it was subjected to it, okay? Heavy trucks, I just assume they all crash tested. No, because they weigh a certain amount, they don't have to be crash tested subject to all the tests at my F-150. What? You mean that my Ford F-150, they're going to take a ram and run into it to see how the fuel tank does, but yet if I drive a dump truck for a living, you mean they're not going to run that same test even though they manufacture a cab and chassis to see how the fuel tank holds up? No, they don't. They don't have to. I'm not saying they don't, but they don't have to. And I dare say that, and I think I'll convince you, that they don't. And I know through cases they don't on those heavy trucks, which makes me wonder why. Well, why don't they do it? If they're really confident in their design, wouldn't you crash test it? Just like if you studied for the test, you show up at school and you take the test. Unless you think you're going to fail and then like, well, I got 3 boys. You know, I'm not feeling good today. I'm just telling you, and we'll cover this, okay? Before we get there, I want to talk to you about all the obstacles that you must overcome before you can even present a case to a jury of 12 people in our community to review a product liability case. A lot of tests that we have to go through before we can ever get to that point where 12 people get to hear the case. One, we've got to have what's called an accident reconstructionist. I really like this work. And one of the reasons I like this work is because you really do get to dig in and try to find out why things happen. And there are some great accident reconstructionists. They can actually come through and figure out how an accident happened, what the speeds were, how the vehicles impact with one another. You remember the picture of the dump truck I showed you just a little bit ago that had caught on fire with the fuel tank on the outside? It was a gasoline tank. Well, I'll just give you an example, and then I'll come back to this script. This was that vehicle, and it was hit by a Buick that was coming in the opposite direction on a 2-lane highway in Bibb County, Alabama. Buick came across the center line, impacted the front of the dump truck. Guess what happened? The front tire on the driver's side got pushed back in. You can see this, right? If you accident reconstructionist does this, they match it all up, and you can actually tell which parts of the vehicle caused damage to the fuel tank. Because in the fuel tank, in this case, there was a rupture, gas came out, immediately ignited, there was a fire, someone died inside the cab. Okay? So one of the first things that we have to do is we have to reconstruct the wreck. The other side's not obligated to do that. We have to do that because we have what's called the burden of proof. It's our case to prove. Okay, now the manufacturer is sitting there because they know the law. Remember, we don't have to have the safest product out there. Just because there was an accident doesn't mean we're responsible. You have to prove that it was a foreseeable collision. So the accident reconstructionist has to demonstrate that this was a foreseeable type of collision. The manufacturer's never going to agree. It's always, oh, this is so rare, this one was unique, this one was different. We have a lot of these things that happen which don't lead to fires. And so there is a battle over, was this a foreseeable collision? For instance, if it's 150 miles an hour running into a barrier, you guys have already agreed with me. That's not really foreseeable. You really don't expect those people to design a product that can withstand that. So we have to show, hey, this was a 55-mile-per-hour collision, vehicle crossed the center line, nothing unique, tire impacts gas tank. You could foresee that happening. All right, let's go back for a second. That's just one thing we have to prove. We have to have a cause and origin expert, which is a fire expert. I know it may sound real simple if you're saying that having a gas tank on the outside of the frame rail is a defective design. Well, you say, okay, well, that's obvious. There's a tear in the gas tank. Gasoline spilled out. There was a fire. I guarantee you they're going, when I say they, I'm talking about the manufacturer, they're going to look for any other possible source of fire. If it wasn't the fuel tank, well then guess what? No harm, no foul. It may have ruptured, but the fire originated someplace else. We have the burden of proof. They don't. You have to have an expert to show not only was it a foreseeable collision with an accident reconstructionist, but then you have to have an expert talk about cause and origin. The cause of this fire was a rip to the gas tank. The origin of the fire was the fuel tank itself. Sounds real easy. Get your first $40,000 invoice from the cause and origin expert together with the $35,000, and then all of a sudden they go, I'm home free, right? No. Then you've got to have a biomechanic or occupant kinematic expert. What that is here's what it means. Some of you may know. Okay, well, great. You had a foreseeable collision. You had a fire, originated with the fuel tank. Your guy had a broken neck. So there was a fire. He was dead. He died from something else. The energy was so great in the vehicle, his head hit the A-pillar on the vehicle. Look, we got x-rays, we got photographs, we got an autopsy. You have to have an expert that explains the movement of the body in the vehicle at the time of the collision. More complicated the collision, start getting rollover, got bodies moving in different directions. You've got to track all that. And you've got to show that if it was a fire, your person died as a result of a fire. I'm just telling you, it's $35,000 invoice here, $40,000 invoice here, and then we get to this almost stepped outside, this invoice here that says, oh, sorry, yeah, you had a good accident reconstructions, had a great cause and origin expert, but I'm sorry, even though the death certificate said died of smoke inhalation, we did an autopsy and it looks like it was a vertebrae in the neck that caused the death. A lot of things to prove before you get in front of a jury of 12 people, and then the design expert, which is the person who says defective. Remember, not just that it's unsafe or could be safer. It's defective, unreasonably dangerous, and by the way, here's a design that was available at the time. Usually these are people who used to work for the manufacturers, who no longer work for the manufacturers, and those people are well credentialed. If it's a vehicle, you find somebody who's designed a vehicle. But, you know, as you can imagine, once that person steps across the line and testifies on behalf of the victim, they're not exactly getting too much work from the other side anymore. Okay? All right, so one of the greatest challenges is demonstrating that the manufacturer knew that the design was defective. All right, so let's just take the case of the fuel tank on the outside of the frame rail. I think it's a defective design. Okay, but they're still selling them like hotcakes tomorrow, selling them all over our state. Every vehicle you see out there is a heavy truck for the most part. The fuel tank's going to be on the outside. They're going to say, well, the fuel tank's so big. Where are you going to put it? That's where the people want it. Nobody's told us we shouldn't do it that way. The government's not complaining. We'll hear every excuse. If you get past those first 4 hurdles, you'll still hear every excuse. How do we show that they knew it was defective? One way is through the crash test. Now remember, I'm going to ask them. On that heavy truck, I want to see your crash test. You know what they're going to say? We don't have any. What? No, we're not required to have them. Look, here are the crash tests that we have. These are the only standards that we have to test to. You're asking us to have something that we're not required to by the government. If the government wanted us to do it, we would have done it. You got a huge lobbying effort out there, coming up with these standards. So what do you mean? How am I going to get crash test standards? Well, I could buy me a $60,000 vehicle and I could crash test it. Some people do that. That seems real easy, right? You better get that crash test right the first time or you're going to be another $60,000 up. But I want to give you the example, all right? Some of you may remember that in Kentucky, several years ago, there was a terrible crash involving a school bus where a lot of children died from burns. And there was a lot of lawsuits that happened. Now, Matt, what does this have to do with what you're telling me? All right? Well, you see, that is the same vehicle as the dump truck, as the utility truck. The only difference is it gets to be a school bus. Remember? It's just a cab and a chassis. It's just a different body on it. Well, if it turns into a school bus, guess what gets to happen? This makes sense. It has to be crash tested. Oh, so if you take that cab with a chassis, now, if it's a dump truck, you don't have to crash test it. If it's a school bus, you do have. Well, now, I may be able to find something here. Now, of course, they don't volunteer this to you. They don't say, oh, yeah, we got one just like, it's called a school bus. They'll say, no, that's not the same. But eventually it comes out, it's the same vehicle. And I look at the law, and the law says you got to crash test that one. Well, I want to see those crash tests, right? I want to see how does that tank hold up when you crash test it when there's a nice yellow body on the side of it. All right? Well, guess what? You eventually find a crash test. Okay? This was after the children died. A ton of children died. Dozens of children died, burned to death inside the school bus. The manufacturers decide they're going to crash test a bus. So, that's the way these things are tested. It's a side impact. It's impacted. Everybody gets up there and says, oh, boy, we got some fluid leaking out of the gas tank. Now, what does that mean? Foreseeable collision. The tank on the outside is probably a bad idea. Well, now, wait. So that means, sure, you can't be right, Matt. Because if that was the case and these buses failed, you wouldn't see school buses out there, would you? The government's surely not going to allow a school bus that has a fuel tank on the outside of the frame rail to be operating kids. I mean, you're surely... come back to that. Oh, that's a fuel tank. Except look closely now on the fuel tank. This is a school bus. This isn't the dump truck. This isn't the utility. You see the fuel tank. Look what's around it. Steel cage. Every school bus that you see now has a fuel tank on the outside of the frame rail, just like a utility truck, except if it's a school bus, in order to pass the crash test, the manufacturer must put the steel cage around it, because if they don't, this sounds like the Pinto, right? Just different location. The manufacturers have taken the step on the school bus because they have to crash test it, and the only way they can pass the crash test is to have the cage around it. But if there's not a crash test for the utility truck, look, I promise you, you'll start paying attention and you'll notice that people die with these medium-sized and heavy trucks because the fuel tank's on the outside of the frame rail. Okay, I want to go back. One way is to show crash tests. Another one is to show other similar incidents. What that means, they're called OSIs. What it means is you try to track all throughout the country. If I've got a 1995 F700 medium-sized truck, okay, I want to know how many other Ford medium-sized trucks across the country have been involved in collisions that resulted in fires. I guarantee you, Ford Motor Company is going to say, nope, we don't have any. What do you mean? Well, you said a 1995 F700 dump truck, right? We don't know of any other 1995 F700. Oh, we know about an F600, wasn't a dump truck. Or we know about an F800. But those collisions were a little bit different. Now, yours, it was kind of a 55 mile per hour. These are 53 miles per hour. Those aren't similar. They're never going to admit there was a similarity out there. But you can dig and find out that there were other similar incidents, and then ultimately a judge has to determine, will I let the jury hear evidence of these other similar incidents, or are they so unique and different that they're not similar in nature? But similarity demonstrates knowledge on the defendant, especially if those other prior incidents resulted in lawsuits themselves. That's what happened with the sudden acceleration cases. You got multiple suits being filed. Eventually, the manufacturer hiring lawyers, they get the knowledge of saying, look, we got people dying, we got lawsuits out there, maybe we've got a problem. Recalls, complaints, it's another way to prove. Alternative designs. Now, I want to fast forward and go back to the school bus. All right, this is what it looks like. That's what the manufacturers place on the chassis cab if it's a school bus. Now, they don't know it's going to be a school bus. All they know is we've got a chassis cab. They find out we're going to send it to X outfitter. They're going to put the body on it to be a school bus. Oh, it's going to be a school bus? Got to put our cage around it. Now, remember, one of the things that we have to prove, not only is it unreasonably dangerous or defective, but we had to prove there was another one out there at the time, right? Another design, an alternative design that was available. It's quite easy when you can show the manufacturer not only knew of one, but was using one. Right? Another way to do it, because you find out, because eventually what happens is someone takes a step forward. Someone takes a step, one of the manufacturers says, you know, that's not a good idea. We're going to do it different. A lot of the vehicles that are manufactured in Europe, as an example, have standards that are a little tougher than in the U.S. And so if the same company manufactures and sells a vehicle in Europe, they may have to do something different than if that vehicle is going to be sold in Huntsville, Alabama. And so guess what they find out? Oh, well, you wanted us to put the gas tank where? Oh, yeah, we can sell it in Paris. We got that room right back there, the back of the chassis. We'll just put it back there, right? I mean, it's inside the steel cage. Good to go. In the U.S., they'll say, nah, we don't have enough room. In Europe, yeah, I've got plenty of room. It's not easy to get there, but you show that they are, in fact, doing it different. Look, there's another example. There's just a fuel tank that's mounted in the middle of the frame rail. Protection of steel on both sides. The last way to prove, and this is where I'm going to end it, okay, because In the GM case, you heard people that eventually had to appear in front of Congress, and as dysfunctional as Congress can be, occasionally they ask some good questions. And they were asking these folks questions, very good questions that I think anybody who was reasonable would ask. When did you first start getting these complaints? And did you document those complaints? And when you documented those complaints, did you have meetings to determine what you needed to do as a company to fix the complaints if you could? Oh, you came up with ways to fix it. When did you do that? Did you consider how much it would cost to make the change? And then if you came up with a decision to how much it would cost to make the change, why didn't you do it? Very good questions. We saw GM really being grilled hard. And they took a pretty good approach, brought a new CEO. I'm sorry, company made mistakes. I'm going to clean it up. We're not going to do it again. We should have done something different. Remember, I said not a lot has changed since the Ford Pinto. In the Ford Pinto case, this is tough. The company sat around and said, the design is bad. It's defective. We've got an alternative design. You place the fuel tank someplace else. How many of those Pintos did we sell? Okay. How much will it cost to retrofit it? Okay. How many people do we think will die if we keep it just the way it is? Okay. How much will we have to pay our lawyers to defend us in those cases? Okay. How much do you think we'll have to pay in either settlements or verdicts if we don't make the change? All right? Just as an example, there's the Ford memo. Y'all can go Google it tonight when you get home. The Ford Pinto memo. I've given you some excerpts here. Just as an example. $2 million to fix it. $1.5 million to pay off in settlements if we keep it the way it is. Some bean counter said, well, that's easy. We keep it the way it is. We save $500,000. Surely not. I guarantee you, because it happened in the GM cases, the same equations were done. How much is it going to cost to fix it? How much will it cost us if we don't? I can assure you, from handling product liability cases for 12 years, it's not as explicit and as grotesque and as callous sometimes as you see it in the Pinto example, but you see a lot of equations about if we make this change, it'll cost that. If we add this rail, it'll cost this. And eventually, companies do make decisions based upon money. Some of them do. Fortunately, the law in the state of Alabama is when you can show a defective product and you can show an alternative design and you can show that it in fact had a proximate cause of the injury that you claim, that 12 people get to decide the facts. Sometimes they say, you know what, we hear you, bad injury, but we're siding with the manufacturer. Many times they say, you mean you knew it and didn't do something about it? Now, I don't know how much enjoyment professionally, because I do believe that we're all called to do something meaningful with our lives. I do. You know, I'm not saying I do it every day. I try. I'm not saying I do. But I think this is a meaningful area of the law. And I think there's still work to be left done. I think when you go home tonight, and if you just look at the vehicles, every time a heavy truck passes you on the road, I mean, those are hard-working people driving those vehicles, men, women, they got spouses and children. And in many ways, we think that we've made progress. I think after you listen and think about what was said tonight, you'll see we still got a long way to go. And there's still a reason that we have laws in the state. And product liability law is still an area where juries get to make changes. In a lot of the cases we work on, as a condition for resolution, the families want a change to be made. There's no amount of money that will bring back a deceased person. But I hear it a lot, families who say, I don't want someone else to have to go through it like I did. And product liability law in the state of Alabama is one area where that is still alive and well. All right, any questions?
A comment and a question. A young lady tonight, and it just happened this afternoon, had two 4-year-olds in the car. She ran off the road a little bit, overcompensated, and flipped her car. It rolled. Both kids were in their car seats. The kids did fine. Mama didn't have her seatbelt on. She was holding on to the steering wheel so hard she didn't even move, even though the vehicle was upside down. All the windows busted out. The vehicle held up. She got a scratch. Neither of the kids were hurt. The comment. But my question, you mentioned the European standards versus U.S. standards. European standards have a requirement for rear-end collisions protection on tractor-trailer rigs, whereas in the United States we have that little thin bar that's a guillotine. When are we going to come up with some kind of standard for the rear of a tractor-trailer rig?
The question was that, you've got on the back of a tractor-trailer, because that's a very foreseeable collision. You're going down the road and you may have been involved in a rear-end collision before in the past. Well, if it's an 18-wheeler, one, it's not going to crumple, and so the energy on your vehicle is going to be much tougher. Well, for the longest time, there was no protection back there in the U.S., and so cars would just go right up under an 18-wheeler. The top half of the vehicle would be taken off, and whether you're wearing your seatbelt or had an airbag or not, chances are you're going to die. We now have a bar on the back, which is a step in the right direction. The question was, when are we going to go to a European standard? I'll just say it this way. As long as we don't require the manufacturers of vehicles to crash test their vehicles, you're not going to see a change. The change starts with having a standard that's applicable to medium and heavy duty trucks in this particular case, because when they're tested and they fail, then a design change must be made. I thank y'all for your time tonight.